And if you have any questions that you may have, please feel free to send them to us. At the end, we will make sure that we try our best to answer all questions with answers as far as what you're presenting, but there is a possibility that we may not be able to get to all of the questions. And if that is the case, please forgive us, but we will try to do our best as far as answering all the questions are concerned. Well, I don't want to take up too much time and belabor the point of us not getting to the excellent guests and individuals that we have here this evening. So I would like to introduce our moderator, who is Melissa Labriola from the RAND Corporation, and I will turn it over to her so that we can begin our panel.
Well, thank you very much, Derwin. And thank you, OAR, for hosting this event and speaking about alternative sentencing and diversion. I think we're all really excited. And we're really excited to hear from all of the participants. So thank you also for joining. And please, I really stress, please feel free to ask any questions. We really want this to be an open dialogue. We want to learn from you just as much as you want to learn from us. So please feel free to put in those questions. And I want to thank our panelists. So we're going to get to the introductions to just a moment. But just a brief introduction about myself. I work at the RAND Corporation. I'm a senior behavioral scientist at the RAND Corporation. And I've been working for a really long time on this idea of diversion, right? So just the idea of changing the status quo and developing innovative strategies, whether at the police level or with prosecutors or with the court, in terms of kind of diverting or providing alternative sentencing to offenders instead of just sending them to jail. So this might be treatment programs, this might be some sort of services, this might be GED, they really run the gamut. I am currently working on several research projects. One is a randomized control trial in San Francisco, looking at their restorative justice pretrial program called Neighborhood Courts, and that is a prosecutor-led program. I'm also looking at LA DOOR, it's in Los Angeles, and they're working with essentially homeless population that have some sort of criminal experience and diverting those individuals away with services and programs. I'm doing a multi-site police-led diversion, which is very interesting. They often call their programs deflection programs, which I think we'll get to language in just a second. But these are police-led. So it's in this case, it's self-referral, people who are going to the police station to ask for help and being diverted away from the criminal justice system. But most probably importantly is I worked on a multi-site prosecutor-led diversion project years ago. And I think what the number one takeaway from that is that jurisdictions are implementing these diversion programs and they all really look different. And what we learned from the prosecutors and stakeholders when we were there was that it really depended on the populations in which they were trying to serve, services and programs that they had at their ready, because a lot of this is a resource issue. And it just, some of them were pre-plea, some of them were post-plea. It was really just kind of what worked for each of the programs. So with that, I'm just excited that there's a discussion about this. I think that it's really being implemented all around the country, these diversion alternative sentencing programs. And it's just exciting to talk about it. And there's such interest. And we really hope that you learn a lot today. So with that, maybe we'll take our poll. So we have a poll that we would like all of our attendees to take, just to kind of get a sense of what you know right now. And so I think hopefully all of you can see it on your screen. We'll just give a few moments to take the poll. Well, great. Thank you so much for all of you who took the poll. So it is nice to see that 82% of you had heard of OAR. That's wonderful. And 82% had heard of diversion programs or alternative sentencing. 82%, I bet it's the researcher in me, they believe this is probably the same 82%, is they're important programs. Perfect. Okay, well, thank you very much for taking the poll. So I think that this brings up, I just wanted to mention quickly on the language, which I kind of hinted at the beginning. So we're going to talk today about alternative sentencing, and we're also going to probably use the term diversion. I think that right now, because this is such a burgeoning, at least research topic, the key distinction for researchers and practitioners is the admission of guilt issue. That a lot of alternative sentencing programs have. So there's some sort of admission of guilt. And however, in a lot of pretrial intervention programs, they do not have that admission of guilt. So the alternative sentencing, there is still some sort of sentence. This is not a blanket case. This is kind of in general. And then with the pretrial, there's kind of a less of acceptance of responsibility. So I just think, right now, I think we're kind of using the terms interchangeably. So maybe when the speakers speak, you guys can also kind of talk about how alternative sentencing and diversion is working, obviously, in your jurisdictions, which might be helpful for our audience as well. So let's get started and introduce our panelists. So I think first, I think all the panelists are going to take about a minute to just introduce themselves. And so let's start with Commonwealth Attorney Descano.
Oh, thank you very much, Melissa. And thank you, OAR, for hosting and everybody for being here. I'm Steve Descano. I'm the Commonwealth's attorney for Fairfax County and the city of Fairfax. And I'm really excited to talk about diversion today because diversion has been a key part of the work that we've been doing since I took office about a year and a half ago. It's informed the work I've done in my office. It's informed the work I've done with great stakeholders and partners like the wonderful Biberaj down in Richmond. So we have a lot of stuff to talk about. And what's really important about these diversion programs that we're going to talk about today is that they produce not only more just outcomes, but they're actually better safety outcomes for the community. So diversion programs, for a number of reasons, are really win-win-win. They keep people from being criminalized unnecessarily. They keep them from recidivating, and they actually, in many cases, lead to better safety outcomes for the community. So there's a lot to talk about. It's a burgeoning field, and I'm just really, really excited to be here and grateful to have the opportunity to talk to everybody for the next hour.
Well, thank you. We're very happy you're here. And so how about Commonwealth Attorney Biberaj?
Thank you, Melissa. And I also want to endorse and repeat a lot of what Steve just said as far as the benefits of these types of programs. I would like to say this for starters. It's amazing what has changed over the last couple of years because I've been practicing for about 27 years, and about 26 of them were in PTSD environments where we just were never given an opportunity to look at our community and try to think about alternatives or innovative ways to figure out is how people get justice involved and what the dispositions should be. So now this is a national conversation. Everybody's realizing that, as Steve indicated, it is a win-win situation. Safety increases when we're doing alternative programs. We have a return of an investment with our finances because we're not wasting and throwing away money. And then it also provides community stability. And when we have our partners with law enforcement as well as the bench, just as Judge Lindner here, then what we end up doing is we have actually a community approach. So that's the best thing about this conversation is that, a couple to 3 years ago, this would have been crazy talk, right? A bunch of liberals, what the heck are you guys doing? You're making our community unsafe. And now we're seeing the rewards that are being reaped by our community. So thank you, OAR. Thank you, Melissa, for being the spearhead as far as having this conversation and research, because I took notes and I'm going to follow up with a lot of things you're doing. But thank you again for having us.
Great. Yes. And please follow up, everybody. And Judge Lindner.
Well, thank you very much, Melissa, and thank you, Derwin. I don't think I've been hearing your name for years, but I've never met you. It's nice to. I don't think anybody really cares where I came from, but I was a software developer in my first life, and at the age of 36, decided I wanted more meaning, went to law school, practiced criminal defense for about 2 decades, and became a substitute judge in Fairfax County General District Court in 2000. 2010 and became a full-time judge in 2015. And I have presided over one of the court's diversion programs in my court, which is a veterans treatment docket.
Great. Yes, thank you. And yes, we do want to hear about Magistrate Judge Lindner. So I think before we get started with the questions, I really wanted to kind of start with just the overall question of what diversion alternative sentencing looks like. But Judge Lindner, I'm actually going to start with you because I know that there's a new statute that's going to go into effect approximately July 1st. And so I was hoping you could just discuss that because I think not only from your judge's perspective, but also kind of how you think that's going to change your work and just the work that's being done. If you kind of wanted to, I don't mean to put you on the spot, but if you could open our discussion, that would be great.
I expect to be put on the spot. You're talking about 19.2 and 298.02. It's a brand new law that was passed and was emergency legislation. So it's in effect now and has been for about 2 months, I want to say. It was written by Senator Surville, and it basically changes the entire landscape of what judges can do. That is the bottom line is that prior till now, and I have a bunch of prepared stuff I could talk about, but really the state of the art for any judge in Virginia is very, very limited in terms of what they can do outside the box. There are a few statutory ways cases can be diverted, and that's it. And the rules generally ban if someone pleads guilty, funny you mentioned that they cannot be diverted, the case can never be dismissed, and we had our hands tied. So this statute, while I will tell all the participants and panelists, I'm not really sure exactly what it says quite yet after having read it 100 times, but what I think it says is this, that the court, without any plea of any sort or a plea of guilty, not guilty, or no contest, can divert any charge with the agreement of the Commonwealth attorney if the Commonwealth attorney is involved in the case, and continue it to some other date with terms and conditions, you name it, treatment, community service, could be anything, go to your doctor appointments, you name it. And after a period of time, the charge is either reduced or dismissed with or without a finding on the first court date. There are some technical weirdnesses about the law, like you can't do this disposition and appeal your case. But that's basically what the law says. And it's a huge answer to a real gap in judicial ability, giving people, I think, tend to think judges can do whatever they want. And it's not true. Judges have a lot of power, but that power is very subscribed by what they're allowed to do with it. So this is, I think, and I can say from the practitioners I talk to every day and members of the bench, I think everyone's pretty excited about this because it does give a lot more latitude in considering each defendant's situation, special needs, history, family, trauma, you name it. So that is 19.2.298.02. And I think a year or two from now, we'll really know what we can do, and it'll be a part of the woodwork of the court.
That's great. Thank you. And do you anticipate, so you said about 2 months ago, so do you anticipate this just kind of a slow, because it's going to be a change of practice, obviously. So have you noticed anything different in your courtroom now?
Well, I've already had the forums in the Supreme Court of Virginia got changed the day the law passed. There was a box for 298.02 right on there. We developed an order, and I've already done about a half dozen of these dispositions.
Great.
So it's happening.
Okay. And Commonwealth Attorney Descano, I guess 2 things. How does alternative sentencing diversion look from the prosecutor lens in Fairfax? And then how, can you speak to what Judge Lindner was just speaking to regarding the new statute?
Sure, I would love to. As a matter of fact, I helped write that statute. So I'm very, very excited for the statute. And I know that, some of the more progressive-minded Commonwealth attorneys, including my esteemed panelists, were very, very interested in allowing for more diversion possibilities. And as a matter of fact, it gives prosecutors a greater opportunity to present to the court these types of diversion agreements. And what's great about it is that unlike past statutory diversion abilities that the court had, these findings won't get entered, which means that this will not result in a criminal record for individuals. So prior to the statute, the small amount of diversion that was available in Virginia would still leave individuals with a criminal record that they could not expunge. So this is a huge step forward. And as far as our current programs, I think we have a bunch of great programs. We have things like drug court, mental health court, but they are reflective of the limited ability for diversion in the first place. And I say that because they're very narrow, they're very small in scope, and they're still very tied to the court. Whereas I think the move forward is the deferral and dismissal programs, which would allow individuals to divert and actually divert away from the court and not have it just be an alternative punishment, but to actually get help and do things more in the community. So this is a sea change, and this is the direction we're going in Fairfax County.
And will some of that, some of that power lie with you, especially anything happening before maybe even entering the court? Is that something that the prosecutor's office has the ability to do?
Yes,
or does?
so the prosecutor's office has the ability to reach an agreement with the defense attorney with terms and conditions. We would then present it to the court for acceptance, and if the court accepted that agreement with the terms and conditions, then it would move forward. Of course, as Judge Lindner said, even in cases where that doesn't happen, the judge themselves, with the concurrence of the Commonwealth's attorney, would have the ability to enter into that deferral and dismissal as well. So it really does open this up incredibly widely, and it just brings Virginia forward by leaps and bounds on this.
Sure. Great. Okay, and Commonwealth Attorney Biberaj, can you talk about Loudoun County? How does it look?
This change in the statute actually has been a huge game changer, because when I came in office in January of last year, we tried to do what we call general continuances, where you put conditions on somebody that they satisfy, so that when the case comes before the court, is with the intent that it be null pros or dismissed or some alternative amendment. And we did have the challenge of the judges, as Judge Lindner said, because they felt that the law didn't allow them to do that. So they didn't want to be in violation of the law. So it was really a tough challenge. So this gives them the authority to be able to do that. We have been using it. I think one of the best opportunities I can say that we as an office had early on is when we had a person who got charged with 7 grand larcenies, and it was like petty larceny third. And what was happening, and this was before they amended the offense to the $1,000 threshold, but it was because he had stolen some food items from Wegmans, and he had gone and had the whole series of those charges. And when we have the case in our office, we'd handled it a certain way. And I remember meeting with the judge, and the conversation was like, well, you guys are just dropping all these charges. Today your office no process 7 out of 8 charges. And I kept thinking, how do we have 7 grand larcenies in the court at one time, not realizing it was one accused? And then once that fleshed out, I responded to the question, he was stealing food, right? And he was military, so he was a former vet. I'm sorry, he's a vet. He had mental health and he was homeless. I am never putting somebody like that in those circumstances in jail. It costs us $166 a day to incarcerate somebody. So if we as a society failed this individual, doesn't he deserve to be given the opportunity to do that? So when we have cases like that, this is why this statute is so awesome, because you're allowed to look at the circumstances as to what brought the person here in front of the court to say, okay, now how do we change their circumstances? Because otherwise, what are we doing all day long is we're putting money in and not getting a return. We're putting money in and not getting a return because people being locked up, they come out not any better, not any more stable. And we just keep creating that recidivism cycle. So this is amazing. We do use it in Loudoun County. I think the best thing about it is that this is an endorsement by the General Assembly to judges saying, not only are you authorized, but we're actually looking for you to use this. Be creative and innovative in how you're handling cases. So I think that was the best thing that happened to criminal justices. General Assembly is in their actions telling judges, you're okay. You're not going to lose your job if you do something, that is appropriate for your community. And I think that was some safety net that our judges needed.
Do any of the panelists have any sense of kind of why? So why now? Was it just, I mean, like you mentioned, a sea change? Was it just what made the General Assembly feel as though this was the time to make this change?
Are you going to say the first name? I'll say the last name, Steve.
Well, I was gonna. I'll give you. I'll leave the full name for you, Buta. But
George Floyd was a big impetus.
Yeah.
Right. Because people started thinking about what are we doing as a nation with criminal justice. So people actually started having the conversation, started paying attention. Then you had a lot of corporations and nonprofits, and just in the core of our moral fiber, we started looking about what are we doing as a system. So Steve, I didn't mean to cut you off, but I thought that was going to be a little tag team, but you failed.
No, that's fine, Buta. I'm glad you tackled that, and as always, I am always happy to hear you talk, because I always learn so much when I listen to you. But what I was going to say is, in addition to George Floyd, there was also, let's face facts, in Northern Virginia and in a lot of places in Virginia, more reform-minded prosecutors such as myself and Buta, we got elected, and what that showed is that this is reform-minded prosecution, progressive prosecution is something that people not only on board for, but they're voting for. I know I beat an incumbent. I know other people beat incumbents who were not as reform-minded, and that was an endorsement to a lot of these state legislators to really hear the message that criminal justice reform and doing things such as diversion programs is really what the people of Virginia want. And they heard that message loud and clear. And after the George Floyd incident, as Buta mentioned, that those two things combined together and gave the General Assembly the opportunity to really tackle this and show their voters, show the people of Virginia that they heard them loud and clear and they share the same values, and we're moving forward in our criminal justice system really for the first time in decades. So it's very exciting.
That's great. So there seems to be in both Loudoun and in Fairfax this change, not only with the law, but just a change. And what I've learned just speaking with various jurisdictions is that there has to be that partnership and the resources to be able to enact, everyone can be open-minded and understand that people need services and treatment and other things, that there's maybe a root cause that needs to be addressed. Do your counties, I don't know, I guess, are there gaps in services? Are there enough services? Are there just kind of, can you speak to just kind of, I guess, just the environment in terms of what can be done?
Gaps in services? Yes. Enough services? No. Right? Because it's a resource thing. It's easier for us as a system to think about the punishment factor, because it's almost like it sells well. We punish somebody, here's the consequences, now here they are. And what ends up happening is when you start looking at that process is you realize you literally are throwing away people and you're dismantling the fiber of our community. Because when you take somebody who, and let's put this in its proper context, we're talking about individuals who are not violent, right? Because that has a different approach to it. But we're talking about those who are committing property crimes or who are using drugs, things of that nature, status offenses. It's just that becomes the part where we just by default, we were putting people in jail or removing them from the community. But what you end up doing is not only are you removing that person, but you're removing a parent from a household. You're removing a wage earner from a household. So that's the tough part. I think what we're doing right now as a system is we are trying to navigate the resources, because I'll speak for Loudoun County. We're pretty affluent. We've got a lot of opportunity for us to be able to invest in these, but we're very siloed in what we do. And, so everybody does something good, but man, if we could get together, we would do some things great. And just like what OAR that we're talking about here is trying to figure out is how do we navigate the nonprofits? How do we navigate, the county? How do we navigate the court system? How do we put those together so that what we end up doing is we are meeting the needs of the individual where that person is? Because cookie cutter result, it's almost like going to a medical doctor. If the doctor gives everybody the same prescriptions, you're not really meeting the needs. I mean, you might help some, others, who knows? Same thing with criminal justice. You can't have a cookie cutter disposition because you're not addressing the core issue. So that's the report from Loudoun.
Fairfax?
Well, I'll tell you, and and maybe Judge Lindner, I think you probably agree with this, that the resources aren't where we'd want them to be. The options aren't necessarily where we want them to be, but we're getting there. And I think what we're seeing is it's almost a reimagining of our criminal justice system as a whole. right? So what we're seeing is we're seeing some services and some funding for lower level obvious things that are easy to spin off from the criminal justice system proper. But I think as more and more people come to realize the safety benefits and the anti-recidivism benefits of diversion for a wide array of individuals and a wide array of offenses, what we're really starting to see is a complete unwinding or a reimagining of the system itself. Because right now, what we're dealing with is we're dealing with the lowest of the low level offenses. And what we really need to do is we really need to start thinking bigger. You know, we really need to start thinking about not only nonviolent misdemeanors, but maybe some nonviolent felonies, because study after study has shown that it leads to better safety outcomes, it leads to better lifelong outcomes. But to do that, there needs to be an almost reimagining of how the system works, so that no longer are we just taking resources and putting them on top of the criminal justice system, but we're actually rebuilding the system as a whole to encompass those resources. And that's, I think, the next step. And I think in Fairfax, that is where we'll probably be going over the next few years.
That's great. Judge Lindner, do you have anything to add? I don't want to.
I will. So I think I agree in part and disagree in part. So in Fairfax, I'm trying to remember when Natasha McKenna was, but I think it was about 8 years ago. A female was killed in the jail, and she suffered from mental illness, and there were all sorts of issues, and it really did result in a huge movement in Fairfax, which is also extremely wealthy, called Diversion First. I'm sure everybody who's watching this has heard of Diversion First, but the occurrence of that timing really helped stand up these diversion dockets in our court and treatment dockets in our court. Stacey Kincaid really made it her business to figure out how these dockets worked, traveled the country with a bunch of judges and a bunch of people in the community, bunch of stakeholders who have nothing to do with the courthouse. And Judge Escarati really did stand up a veteran treatment docket in 2015. So, and I want to say that I'm not allowed to talk about what should be or what ought to be or what we need to do. I can only talk, because of the canons of judges, I can only talk about what is, but I will say that the treatment dockets I've worked on are enormously beneficial. They help people, to use Buta's words, exactly where they are. And the magic of the veteran docket was we could use the VA to get people services that would otherwise have been difficult for them to obtain. However, I do agree with Mr. Descano that that big, expansive thinking is on the rise. And to the extent that it results in more public safety and less recidivism and doesn't destroy people's lives while holding people accountable in some way, that's good. And that's what justice should be. I want to say one more thing, and I know we're limited on time, but I think it's important. Many of the people in the world I work in, many judges, many lawyers, many prosecutors, do not agree with that. When I was the presiding judge in 2016 of the veteran treatment docket in Fairfax, which was really one of the first in the state, I had, I guess, the privilege of speaking to all the general district court judges and JNDR judges in Virginia at a conference, and I got 6 questions about my presentation, and they were all the same question. Why should a veteran get treated any differently than anybody else? And until or unless state legislatures and federal legislatures and prosecutors en masse and public defenders and judges, everybody kind of rejiggers the way we think about this process, we are sort of stuck. We're stuck with an ancient system that was invented when, you know, lawyers wore wigs. And it's important to remember that as you redesign the world. So in any case, that's my response.
Thank you. Thank you. I think because I think that the change, this idea of reform. I mean, I think that everyone has mentioned it. Not only are you bringing in, you have to bring in other partners, you have to bring in other stakeholders that the criminal justice system may have never worked with before. So all of that is changing, and then changing people's minds. I guess I have a question here, but just really quick. So is there opposition? And I mean, I know that the judge just, right, that there are people who in all the different facets of the system might, but is there any opposition that the prosecutors are hearing from? Are there people in your office? Are there, who are just, this isn't what they signed up for type of opposition?
I can't speak for judges, and so I'm going to be
Yes,
really short.
and I knew that. So that's why I
And my
wanted to.
answer is yes, there's opposition.
I will say from the prosecutor side that I got to imagine, Buta, you also have some very colorful anecdotes. There absolutely is opposition. There are opposition from individuals who don't like change, individuals who have an interest in keeping things the way that they are, individuals who just simply they want to go with this gut feeling, even though it's uninformed, even though every study after study after study has shown that this worked. I mean, you take a look at a study that came out of Suffolk County in Massachusetts 2 months ago, and a huge study that came out of Harris County, Texas, only a few weeks ago, that shows that not only does diversion keep drop recidivism by anywhere between a third and more than half, but it actually leads to greater employment outcomes for individuals and more stability for families. So it is clearly a win. But what we see over and over again is this old way of thinking, and that's why in my office, one of the first things that we really focus on is building a culture of diversion. I know that I have my prosecutors read books on diversion and write book reports. I have them read books about mass incarceration that we have giant discussions about. And quite frankly, we've weeded out anybody from my office who does not see this way, because you have to, as a prosecutor's office, in the face of all this resistance, you have to be a unified front rowing in that direction, because you have enough headwinds and enough currents fighting against you already. So building that culture is job number one, because Buta, I'm sure you're going to tell us in very good stories about how you also are getting some of the pushback, because I know you're getting it because you're only up the road from me, and I know I'm getting it.
So how I've explained it to people, and I will use a gang analogy, because when we start talking about initiation, it's called being jumped in. And basically what you end up doing is you're in the center of a circle and everybody's just taking shots at you. And my response is, please don't hit the face, because I got to go to work tomorrow. But it really is. It's everybody takes a shot at you, because it is such a change. And the muscle memory is where everybody's comfortable, because if we do it this way, it's always worked. And so why are we changing it? Because we have to have that self-assessment and that self-awareness. It didn't really work. We were comfortable with the way it was because we didn't know any better. We never looked outside of that box, So those of us who were in the defense of individuals, we got to know the people we were working with and seeing the humanity. And I think the system lost that you couldn't treat somebody as a human being, because guess what? They did wrong. Nowhere else do we do that. With employment, if you have an employee who needs improvement, you don't fire them, because you can never run a daggone business. Same thing with the school system, same thing with families. What you do is you acknowledge what the behavior variation is, what the offense is, what they should be doing to do better, and then you give them an opportunity to do better. That's how our criminal justice system has to be, because we want those individuals to be invested so that they can invest in our community, so we're not carrying that sole weight by a smaller number of individuals. And I'll just have one more reference to say is, when we were in school, we would have teachers who didn't care about us, and we didn't care about them. We hated to disappoint the teacher who liked us. And that's the same thing with the system. If the system shows that we're invested in you, you're not going to want to disappoint us. If we discard you, what do you care? Like, you don't care about me, so I shouldn't care about you. So we kind of lose that humanity or that community focus. So yeah, there's a lot of challenges out there, but I'm pretty confident that we are going to weather the storm, because at the end of the day, what we're also going to do is going to talk about dollars, right? Because if I can save my community, we reduced our jail population from an average of 425 and 450 to we're about 250. If it was $1 for dollar savings, we would have saved our community $111 million. who wants to hear anything else, right? And safety has not been jeopardized, right? That's the increase in the safety. We now have a greater resource that we could put into schools for counselors. You know, these are things that take that money, invest it. You want a return on your investment. Stop throwing away money, stop throwing away people. So yes, we get beat up all the daggone time, but we're on the right side of history.
Good, thank you. So I think one of the opposition points of view I've often heard is that a lot of diversion programs require, and this is a question actually from our audience, I'm trying to make it my own, which it's not, but they require defendants to jump through a lot of hoops. You know, there's often a lot more to do, you know, so I mean, drug courts is a perfect example of, you know, there's a lot more to do to successfully complete drug court than say just go to jail for, you know, 3 days, if that. So is there something in place that, like, whose responsibility, I guess, is that the court's responsibility, the prosecutor's office responsibility, is that the program's responsibility to kind of keep people on track, you know when your appointments are, when to go, make sure you're going, that type of, because we know this is difficult and that people often, you know, it takes a few tries before you could be successful.
Can I answer? So the veteran treatment docket again is, and to the limited extent, the mental health docket in my court, which is a behavioral health docket, which by the way, are both drug dockets. They're both mental health dockets. Every one of these is an alcohol, drug, and behavioral health docket, are very, very hard. You're talking about someone coming to court every 2 weeks for 2 years and being random screened twice or 3 times a week, and completing community service and reporting to their probation officer, and it just goes on and on, all their VA appointments. And it is super, super hard. And quite frankly, I was a defense attorney for almost 20 years. There is yet to be a disposition on that docket I couldn't have done better with just by pleading not guilty and having a trial. And so it's a problem of carrots and sticks. There is a need for accountability, but making someone come into court every 2 weeks for 2 years is hard. And not many people are going to say yes to that. Frankly, it's only going to be people who have insight into the fact that they need treatment. What I will say, in contrast to everything we've been talking about and the social justice movement that's afoot, is that working with these treatment dockets, I discovered scientists and clinicians and courts have been working together for 2 decades. This is not new. There are hundreds of drug courts and thousands of alternative dockets and courts in the country. And the numbers all say they reduce recidivism. The numbers all say they lead to better outcomes, and they all save money. The big structural difference in my court is now, because of these dockets, there's clinicians in the building I work. Who would have thought? A social worker in a courtroom. Literally, Buta's right. When they told me I was doing this docket 5 years ago, I was like, what? We're gonna treat veterans in court? And it's a part of the woodwork of the court now. And it is so amazing having the interaction of the scientific community, the social scientists, as well as the clinicians and the statisticians who make all these numbers make sense, to help us develop best practices. Unfortunately, as Mr. Descano emphasized, some of those best practices are just not really tenable in a feet on the ground in an actual courtroom trying to get a case done. It's enormous hard work for the defendant, for the court, for everybody. But I just thought I'd mention that there is progress being made and has been being made, integrating services with court work. And to the extent that that continues, I think that is good.
Thank you. Yes, and I agree. And I think that, you know, a lot of my prior work has been done on evaluating, you know, drug courts, veterans court, and mental health courts. And I think, you know, just that's a smaller population in which this alternative sentencing or diversion options are given, because right, you have to be a specific type of person to be able to withstand all the responsibilities and recognize that this might be the right time for you to want to do that. So are there other ideas, or is there anything else that's kind of opening up the eligibility pool in terms of, kind of making these options for a larger population of people? And are there specific eligibility criteria that your jurisdictions are thinking about?
So with that code section and some of the other changes that the General Assembly enacted, yeah, the pool, boy, man, it's an ocean. It now is something that the only thing that would limit us is going to be our creativity. Because you can have pre-plea programs, and that basically is if we're trying to set up somebody who has consequences, can make the victim whole, account for what they have done, so that they also are having some skin in the game for them to be able to do that. And if they do that before they even can come to court, then what that allows them to do is to be able to have a more immediate consequence, because this is also something that's lost upon people. If you go through the court process, your best case scenario sometimes is 60 days. If you yell at me about what I did last week, I don't remember that. I mean, that's so far removed from the emotional connection that you don't get the change in my behavior as if it's a much more immediate impact. So that's the other thing that we have to look at with these types of programs. We can impact the behavior sooner because the consequence could come quicker.
Yes.
Plus, we could be creative and do more things within the community, so that this person now is having to pay back the community. You could pay the court a fine. I don't know what that means, right? Now you've impacted my pocket. But when you start taking people's time and putting them in service to others, they also meet other people within the community, so it increases their stability factor and their support system. The Judge Lindner, as great as he is, he can't do it by himself. Steve in his office in Fairfax, he and his attorneys, they can't do it by themselves, right? Because it has to be that holistic approach. We as a community need to invest in our community to get the outcomes that we want. It can't be one person's or one system's responsibility. No, it doesn't work that way. So yeah, that I think the pool is definitely has been broadened, and I think every day we study more and we read more and we find another program. We're like, oh my God, that's more amazing than yesterday's program.
Right.
And we're just limited by resources and time as to what we could really put into place.
Sure. Yeah, there's
but
great examples out
Yeah,
out
but I
there.
think
But neighborhood courts in San Francisco, kind of touching on two of your points, you sit in front of community members. The defendant sits in front of community members and they discuss what their options are. And so, and what we hear from the defendants is, right, they don't want to disappoint those community members. So it's not a judge, there's no prosecutor, it's just community members talking with them and discussing kind of what would benefit them and what would benefit the community, and what did you do to the community, and do you see that? And the conversations are immensely helpful, I think, to everybody. Commonwealth Attorney Descano, did you want to add? I feel like I'm.
No, yeah, that's absolutely. I appreciate it, Melissa. But to Buta's point, yes, with the new statute, the pool is wide, and I think what we're seeing is that, as Judge Lindner said, the Veterans Court, the drug court, they are incredibly valuable, but they're incredibly hard, and they're for a certain type of individual that they're really successful for. What we can do is we can be more successful as we start to reimagine different options for individuals, so that it's not a one-size-fits-all approach. There are individuals that we can help, that we don't need to have to come back to court every 2 weeks and essentially make it very, very difficult, where we can create more community-based programs or community supports for these individuals. The fact of the matter is as we really start to reimagine what our criminal justice system and our diversion programs look like, if we have the courage and the creativity, as long as we can find the resources, what we'll be able to do is we'll be able to create many, many different off-ramps, many, many different options for these individuals, with the idea that we can limit the interaction with the court at all, only because we want to reserve the court's time as a resource. We want to reserve that time for the individuals who truly need that level of touch, while not burdening individuals who don't need that level of touch with things unnecessarily. So this new statute is going to be a game changer for us. And I think that in the years going forward, new programs are going to be developed that have the right level of touch, but also remove some of those hoops that in some cases may be necessary, but in many cases simply are not. And that exists simply because we're building off of a framework that we're more comfortable with as we are right now. But as we get more comfortable with change, I think things will change and more options will be available.
And another question from one of our participants is that are there ways that your offices are working to help individuals get their charges expunged prior to automatic expungement becoming available? And so I guess that's actually a question I just don't know. How does Virginia work in terms of expungement?
Well, I can tell you that with the Virginia with expungement right now is very, very limited. And I know that automatic expungement was something that Buta and I really pressed on and really worked hard to speak in favor of down in Richmond. But what's great about the new deferral and dismissal statute is that those charges can be dismissed. So that we can work with individuals, they would go through the normal petition process, but they can be dismissed even before automatic expungement comes into play, which I believe comes into play in 3 years. So that's really what makes this new deferral and dismissal statute so great. In addition to just widening the pool, it actually really does take into account the lifelong consequences of having a conviction on your record.
May I jump in and say, Melissa, I think the fundamental difference here is that there's no way under prior law before the statute existed for anyone who even stipulated facts were sufficient for finding of guilt, no matter what happened afterwards, it's not expungible. Even if the case is dismissed, a 251 disposition on a drug case, an OAR disposition in my court for a petty larceny, those result in not convictions, but a record of arrest and a dismissal that is not expungible. And everyone who's watching this knows we're living in a world where it's not the way when I grew up. That one little dismissal can ruin your life. And so that's the big feature, is that this new statute does not require a finding at the time it's entered.
That's very, very important. Thank you. Another question from the audience. Does this new law apply to juveniles?
Yes.
In the same way? No difference? Okay.
It's in the title that has to do with criminal procedure across the state.
Across all, okay. And
Melissa, may I expand on the juvenile? So the coolest thing about the juvenile process is actually, even before this code section change, in juvenile court, the added language for the expungement was, if the case was no pros or otherwise dismissed. So even if somebody went in there and had gotten a deferred finding, as Judge Lindner was talking about, as an adult, you couldn't get an expungement. In juvenile court, you could. And that process was in that court, and you could do it pretty much lickety split. Whereas with the circuit court, it's a lot more of an involved process and things of that nature. But yeah, thank gosh, the juvenile court approach has been much more liberating for individuals who may make a mistake.
Thank gosh is right. I can think of one judge, me, who had a child who benefited from that statute. And I mean, these are the kinds of things that can ruin people's lives. So having diversion for juveniles in place was a godsend for me.
Great, thank you. And how has OAR, seeing as though there are fine hosts today, how has OAR as an organization contributed to either the work prior to the statute, during, just what's their role in your work?
Well, I'll say I want to jump in because I'm always so happy to work with OAR. They do a fantastic job, and I think they have been great partners with us before, and they're becoming even better partners with us now as the opportunity expands for diversion. But what I think is really important is, too often people in the criminal justice system, attorneys, defense attorneys, prosecutors, judges, we're expert at what we do, but that doesn't mean we're expert at everything. So I think what really is going to be, it's huge in diversion when you do a good diversion program, is that you listen to the experts on the ground, right? And OAR is an organization that provides expertise, so that once we've made the decision to try to divert someone, they'll have the expertise to help us figure out what the appropriate intervention is. Just the same way as other organizations, maybe such as CSB, they have more expertise on drug addiction or substance abuse disorder. So I think it's really important that OAR and organizations like OAR be recognized, not just as a service provider, but as the experts who bring expertise to these systems that actually make them function and work.
Thank you. And in Loudoun County, as you kind of are on this process, any words about OAR or thinking about how OAR could help? Oh, there's a cat.
Yep, he's the cat lawyer or the
Yeah,
cat judge.
Cat judge.
But
Right.
yeah, OAR has always been very impactful in Fairfax County. In Loudoun, we have not given them as great a role in the years past. So a lot of times they were working in the jails, but very limited as to how we were using them in our community. So right now we're actually investigating, researching how we could broaden our relationship with them so that they could actually provide greater services and broader services to our community members. I like the fact that with the reentry programs, we could use them, their assistance. For deferral programs, we could use their assistance. And as Steve said, you know, no offense, I'm a lawyer, right? My skill set, I might adopt the phrase, you know, attorney and counselor at law, but at the end of the day, I'm counseling you about the law. I'm not a true counselor in that sense. And that's what we end up doing, is let's find the strengths of the groups in our communities who can help us carry that weight, right? Because, you know, our learning curve is ridiculous. That's their profession. They can definitely supplement what we need to do so that the individuals who need the services get the right services, so we're redirecting them away from our system.
Yes, an excellent resource to have. You're very, very lucky. So it's 7:52. So any last words or last thoughts about the impact of these programs, or maybe just the direction in which you want to go, the direction you want to see these programs go, the country go? Last thoughts.
I will let other people talk about where they want things to go.
Well, I appreciate that, Judge Lindner. I understand you're limited, but I'm willing. I'm happy to take up the charge. You know, I think diversion programs are the way forward. You know, they show that we don't have to choose between justice and safety. We can have both. I think not only are they a great tool to combat mass incarceration, but they're also a great tool to combat racial disparities in our criminal justice system, because too often individuals get caught up in the system and they recycle and recycle. But if we can get at the root causes, that can help with that issue. And then the last thing I want to hit on is talking about justice and safety. One of the things that people who poo-poo this idea, they talk about victims all the time. But what we've seen is that people who have been victimized by crime, they want diversion, because they realize that these individuals, if they go to jail, they're coming back, and they're coming back to the same neighborhood. And what they really don't want is they don't want the same thing to happen again. They want somebody to help these individuals get at the root causes of their issues, so that when they're their neighbors, their neighbors create safe neighborhoods, and they can be the type of member of society that you want as a neighbor. So this really, diversion is the future. It builds safer, more just communities. And it is actually, I think what we're going to see over the next few years is it's going to take a more central role in what prosecutors, attorneys, and judges think of as good outcomes for criminal justice.
So I'll be the bridge between Judge Lindner and Steve. I was a substitute judge for 11 years, and it's amazing how much your voice does get squashed and how much you really can't say, because you put in that position because of the judicial canons that you can't make comments about what you see in a system that is broken to a certain degree. But my voice was only slightly silenced because I was also an attorney. So, but you know, without the robe, I was talking a lot of smack. But it is the future, and not only is it the future in the sense that the right thing to do, but what we see is with our probation officers. We have probation officers who are saying, "Thank goodness this is the change." Right? Because now they can also be creative in how we are being able to work with that population. You know, we have police officers who sometimes feel like they've been somewhat disenfranchised themselves because we're discounting the work they've done, and we're saying, no, we're not. Actually, what we're doing is we're hopefully keeping you from having to have the repeated behaviors with these individuals, because we're redirecting them and giving them that belief that there is an investment that they're making in the community and the community is making in them. So, when we start being okay with the idea that that person who's coming before the judge is somebody's somebody, and we should treat them as if they were our somebody, then it does make a big difference. Right? Because at the end of the day, we are a community. We have to remember that we are not separated from one another. We're all invested in making sure our community is safe, and through the course that we do provide that justice.
Thank you. And Judge Lindner, not speaking of the future or what is broken or needs to be changed, do you have any last thoughts for the participants?
I just want to encourage anyone who had the motivation to be here, obviously is part of a very self-selective group who care about these things. There are fairly few people I know who are thinking about these things like Melissa and I and Buta and Steve are. And I think I feel free, at least for myself, just offering to give anybody a pep talk if they need a pep talk to stay involved and to get involved. The people who are running this are largely volunteers. This sort of effort requires stakeholders to stay involved. If this is something you care about, get involved.
Well, thank you. And on that note, I completely agree with the judge. As a researcher, if there's any, questions or anything I can help with in terms of the literature that's out there, if there's jurisdictions who are trying to implement something, please always feel free to reach out. And thank you. Thank you to the panelists. Thank you to OAR. And I'm passing this back to Derwin. And you're on mute.
I got you. I knew I was going to do that. First of all, thank each and every one of you for giving your time and being here and sharing all the wonderful information that you've shared this evening. This topic is very near to my heart and OAR's heart. One of the things we like to do before we move forward is we have a final poll that we would all like for everyone to look at and to answer for us. And then after that, I will wrap up our event for the evening. If you were part of this evening tonight, it means to me that you may have some interest as far as diversion is concerned. I look at the results of the survey, and these are important programs for our community. And man, how much do I agree with the results and the finding of that? And to know that 96% of the people that have attended this are interested in diversion, it sounds like we have a lot of potential volunteers for OAR once we open things back up, because we're going to need the capacity and the people to help us to kind of address this challenge and this thing that is being brought up right now. The populations in our adult detention centers are at an all-time low, and we want to keep it at an all-time low. And one of the ways of doing that is to bring upon programs like we're talking about tonight. But in order to increase the capacity of OAR and to allow us to do all the things that we need to do, we need the wonderful active volunteers and the individuals such as yourself to come and engage with us in order to help people to improve their lives and to achieve the dream that we all continue to strive and work towards on a daily basis. I'd like to remind each and every one of you, after this is over, there will be a survey that will show up immediately after the webinar ends. If you can complete the survey, it will be helpful to us because it will allow us to understand how we're able to do more events like this. COVID may not have been the greatest things in the world, but it's brought on some interesting things that we're able to do, and this is one of them. I would be remiss before I go tonight to thank Leadership Fairfax and their class that helped put this on for us. This is not only OAR, but it's Leadership Fairfax. And without you, we would not have been able to do this. And it's greatly appreciated to see the young leadership step up, use some technology, and help us to be able to communicate about an issue that is as important as this. My final word as far as tonight is concerned is an investment in our community can't be successful without everyone joining in, investing, and becoming committed to what we're doing. With that, I will close. I thank each and every one of you for joining us tonight. God bless, Godspeed, and please take care.